Hi, welcome everybody. It's 9 o'clock Pacific time. My name is Giuseppe Leone. I'm the founder of Virtual Mediation Lab, a project sponsored by the Association for Conflict Resolution Hawaii. And today's webinar is titled, Should ADR Professionals Mediate Internal Conflicts? And our presenter today is John Ford. John is a very experienced workplace mediator, and also is the author of a book which is called Peace at Work, the HR's Manager Guide to Workplace Mediation. Before John begins with his presentation, let me explain how you can submit questions. So let me show you. You can see here that at the top of your screen, you should be able to see this panel or audio settings where you can adjust your settings. And if you click Q&A, there is this panel showing up. And at the bottom, if you click this, you can send your questions anonymously as well, if you so choose. So at the end of John's presentation, hopefully there will be enough time to answer all your questions. Otherwise, John will tell you how you can contact him if you have any further comments or questions about his presentation. So let me stop this. And John, take it from there. Go ahead.
Thanks, Giuseppe. I'm pulling up my PowerPoint presentation. There we go. Welcome, everyone. The question which I intend to address today, namely, should HR professionals mediate internal workplace disputes, in a sense, really requires that we address two further questions. The first question, and this is partly a due diligence piece, is what is mediation? And allied to that, in other words, in addition to that, looking at the definition of mediation, we need to consider when mediation is suitable, in other words, where and who can conduct the mediation. And that'll lead us into the second part of this first question, which is really sort of asking the question, should organizations actually be using mediation to address their internal workplace disputes? If we get a yes to that first question, we can move on to the second question, which is really the foundational question of this webinar. Should organizations be using their HR professionals to conduct these mediations? Now, for us to answer that question, we'll need to look both at the arguments for HR professionals mediating internal workplace disputes, and I intend to look at information both here in the United States, but also in the United Kingdom. We'll have to consider the arguments against HR professionals mediating internal workplace disputes. Along the way, I'd also like to share with you what I see, or where I see the bright line existing. In other words, that distinction that helps us to know when it's safe and when it's not safe to mediate. And I'd also like to share with you as we go along, or towards the end, some practice tips for conducting mediations yourselves, and also some learning opportunities with the HR Mediation Academy. We'll also be sending a replay of this webinar, so you'll be able to watch it at a later point in time if you don't get to catch it all now, and also the full PowerPoint deck. So you should get that at the end of the webinar. Before we go much further, I wanted to thank you, Giuseppe, for being the host, and also Jim at mediate.com for sponsoring this event. I'm truly honored and looking forward to getting into the substance. But one last thing before we do get into the substance, I wanted to share with you the story of how I became a mediator. Because as Giuseppe mentioned, I have written a book, Peace at Work, and when I was writing that, I started sort of wondering, well, how was it that I became a mediator? And it was kind of interesting because I discovered, or I surfaced what I would just describe as an old memory, something that I'd almost completely forgotten about, and it pertained to me being a young kid at school in South Africa. You can see it was 1975. I was about 13 years old then, and I still, as I've now reconstructed that memory, remember very clearly the day that I discovered that Peter Fowlis had fabricated a conflict between me and another boy called Paul Hazeman. And the way fights, and I hate to say this, took place at our school was that there was a fight venue at the top of one of the fields. And all I know is that I was filled with dread and fear on this particular day, not knowing what to do, because already at that point in my life, I wasn't really a fighter. And the deal was, at the end of the school day, when the bell rang, I was expected to walk across to the fight venue and face my reality there. Well, I didn't do that. I took the long walk home across the field, and on that long walk across the field, an agonizing walk, I had to listen to my friends jeering me and calling me things like chicken something and a coward. And so it was on that day that I discovered a couple of things. Well, firstly, as I say, I knew I didn't like the idea of fighting and being aggressive, but I also didn't like the idea of being a coward. And I took that on in a way, but not in a conscious way, because, as I say, I did a good job of suppressing that memory. But what I've realized is that my career in many ways has been attending to that very question, and that through mediation I discovered that there was a way to collaborate, that I could assert myself, and that I didn't have to show up in life as either a coward or a bully. So that's just a little bit about me. And just to say, the focus of my career has pretty much been exclusively on the workplace and supporting and helping HR professionals mediate themselves. As we get started, I thought, out of curiosity, how about checking in to see what your views are? So Giuseppe, if you could run that first poll for us, and if
Sure.
folks could just indicate where they stand in relation to this question. We'll check in again at the very end, but in respect of the question, should HR professionals mediate, we're looking either for a yes, a no, or not sure.
Okay, hold on a second. Okay, so let's launch the poll now. So you can submit your questions now. Okay. All right, so we're almost there. Okay, so let's send the poll now, and let's share the results. So 46% of you think yes, and 26% of you think no, and 31% are not sure.
Ah,
okay.
Very interesting. I actually conducted a similar poll myself online, and there I had 62% saying yes. So we have a lower number for the yeses, a high number for not sure, and it'll be interesting to see what results we get at the very end when we check in again, just to see where people are. Let's now move into the real substance of today's presentation. So as I said, the first question, to me, it's really a little bit of a due diligence question, because I know there's probably a lot of you that are really familiar with mediation, but just to make sure we're all on the same page in terms of what mediation is, and as I say, where it can be used and who can do it first, and then we can look into that question of whether organizations themselves should be using internal workplace mediation. So the first thing we can say is that mediation is not toxic triangulation. And the therapists always remind us that there's something risky about triangulation. And mediation, of course, is premised on a form of triangulation. But there's, as I say, there's a risk involved, and that risk occurs when two people, A and B, are in conflict, and B runs off to that third person. Instead of that third person holding the stance of the mediator, that third person tries to play the role of the hero, tries to rescue the victim, and teams up against the villain. And when that occurs, we have toxic triangulation, and that's not what we're looking for, and that certainly is not what mediation is. Mediation really is about restoring responsibility where it rests, in other words, to the two parties in conflict, and supporting them to find a resolution that works for both of them. My fuller definition that I use in my book is that mediation is a conciliatory process. In other words, it's not an adversarial process in which an acceptable, and you'll note that's a very specific word, it's not neutral, in which an acceptable third party intervenes in the conflict or dispute of the participants with the goal of supporting them to reach an agreement. And that's a pretty standard definition of mediation. If we want to really dummy it down and get down to the essence of what mediation is about, we can say that we mediate anytime we help two other persons to resolve their differences without telling them what to do. So what this really means is that in mediation, the key is that the mediator is not the decision maker. The participants are. Now, there are a couple of myths that I believe are sort of floating around. One of them is that mediation is something that happens in the courthouse. So the first thing I think we need to sort of get clear on is that mediation doesn't just happen in the courthouse. If we look at this little map showing the genesis of a conflict and the choices people make, we can see that there's both an internal, often a more informal and sometimes referred to as a small m mediation opportunity internal to the organization, and then there's also external opportunities. So let's sort of see if we can watch how a conflict could potentially play out. Sometimes, and they say around about 50% of the time, people avoid. Well, when people avoid conflict long enough and they're unhappy, they often quit the organization. That doesn't mean it's the end of the road, and we'll get back to that in a moment. Another thing that people will sometimes do is complain. And when they complain, there's an investigation. After the investigation, management makes a decision. If everyone's happy with that management decision, happy days, and we're all back, everyone gets back to work. But if someone isn't happy with that management decision, what will often happen is that the conflict leaves the organization. And here in the United States, what that would mean is that one of the participants or the employees would file a complaint with either a state or a federal agency. The DFEH is in California, that's the Department of Fair Employment and Housing, and the EEOC is the Equal Employment Opportunity Commission, that's the federal agency. Well, here's the deal. Both of these state and federal agencies are going to offer mediation. A lot of the time, mediation leads to a resolution, but when it doesn't, the parties head off to court. Well, guess what? When you get to court, they're going to offer mediation. So clearly, the jury is in terms of using mediation for disputes external, the disputes that leave the organization. And some of those may also come from the person that avoided, because they could also go off and file a complaint. But on the other hand, there is the option of not avoiding, of not complaining, of collaborating, and of collaborating internally and using mediation in-house to reach and to find a mutual agreement that both participants have said yes to. It doesn't absolutely guarantee that there won't be anything happening externally, but almost I'd say it gets very close to ensuring that. So the first point that I really want to make here is just to say is that mediation doesn't just take place in the courthouse, and that there are tremendous opportunities in-house. In the sense, the mediation that's occurring external to the organization, that's often framed as alternative dispute resolution because it's the alternative to going to court. And for the mediation taking place inside or within the organization, that's often referred to as internal workplace mediation. Now, there's another sort of related myth that sort of seems to be out and about there, which is that you need to be an attorney to mediate. Now, while I support, and I myself studied and practiced as an attorney myself, I support the use of mediation in the courthouse, but the truth of the matter is you don't need to be an attorney to mediate. In fact, if we ask that question of who can mediate, and with a focus on the workplace, we can see that managers can mediate, HR professionals can mediate, professional mediators can be brought in-house to mediate, and some organizations, like here in the San Francisco Bay Area, where the UCSF campus trains a cadre of their internal employees to conduct mediations between other fellow employees. So clearly, it's not just attorneys that can mediate. Pretty much anyone can mediate. So we've looked at the sort of the question of what is mediation. As again, to me, that was our due diligence sort of inquiry. Let's shift to the second part of the question, which is, should organizations be using mediation to address internal workplace disputes? And the first sort of place that we can sort of go to, and this is actually going to be focusing at this point on those conflicts that have left the organization. But the first point to make is that conflict costs a lot of money. In 2010, and I don't believe this figure is any less in 2017, but in 2010, the Rand Institute for Civil Justice estimated that it cost, on average, $150,000 to defend an employment discrimination lawsuit in the United States. That's a lot of money. The Hiscox Insurance Company have done some research, and they were looking at which states in the United States were most at risk. And in general, U.S. companies have at least an 11.7% chance of having an employment charge filed against them. Some states like New Mexico, that's a 66% chance, California 40%, Nevada 47%. So clearly, organizations are operating in a high-risk environment where there's a real a chance of ending up in court where it costs a lot. The same Hiscox study found that on average it takes about 275 days, that the average payment is about 125,000, and then that 19 and 81% is particularly interesting. 19% is the number of matters in which there's a payment. Now, typically, the insurance companies aren't going to pay unless there's a perception of exposure. So we could really say that in about 1 in 5, there was a perception of some exposure. 81%, that's almost 4 in 5, there was no payment. And what that often means is that people are negotiating the deductible away, because the company sort of thinks to themselves, I have to pay the deductible to get the insurance company to pay for this. So they try and negotiate a deal for something less than their deductible. And that's probably around about 81% of the time that happens. And I certainly saw a lot of that when I was an EEOC contract mediator. On the other hand, we have the reality that there is data showing how mediation saves. In 1997, Cornell University and Price Waterhouse conducted a study of Fortune 1000 companies. And what they found was that about 90% viewed ADR techniques, alternative dispute resolution techniques, as a critical cost control mechanism. And 88% reported using mediation in the last 3 years. They followed that study up with another in 2011. The figures are the same, and the results are really confirming the same thing, is that the perception is that mediation saves time, it saves money, it preserves good relationships, and a lot more. But what I want to just point out is those figures that I've been sharing with you really pertain to mediation external to the organization. Now, of course, if we don't resolve our conflicts internally, that's where they end up, and they do end up costing us a lot of money. But what about shifting our focus to look at mediation internal to the workplace and to see if there's any justification for it taking place there? In the United Kingdom, Professor Stephen Wood, an employee relations expert at the University of Leicester, suggests that employers are failing to adopt mediation in the early stages, despite the fact that it could help them avoid these more formal, costly procedures or indeed litigation. And what he's also really pointing to is the fact that there are a lot of hidden internal costs of conflict that are really costing an organization continuously, even when the dispute hasn't made its way to a federal or to an external agency or to the courts. If you think about any conflict that your employees are involved in, we can do a sort of a very simple math sort of calculation to calculate the amount of time they've all spent on that conflict and then multiply it by their salary. But the reality is that employees are spending a lot of time dealing with conflict. It's estimated that senior HR executives spend up to about 20% of their time in litigation-related activities. That's 1 day out of the week. 1 in 5 days is being spent in litigation-related activities. That's a lot. In the United Kingdom, the Chartered Institute of Personnel and Development came up with a figure of 30% for management time spent on dealing with conflict at work. Not only is there a lot of time spent on conflict, when people are in conflict, decision-making quality is reduced. So we only have to think about that as another factor that's influencing our decision. We also need to take into account the absenteeism, the stress, and the sabotage. So the bottom line, or the reality, is that there's a lot of ways in which organizations are already paying for the unresolved conflict without even realizing it. In addition, there's the cost of turnover, and that can be anywhere between 30 to 150% of that employee's annual salary. So losing employees, not retaining them, is costly, and we know that a lot of times employees leave because of unresolved conflicts. So here's the deal. Organizations need a variety of tools to manage conflict. Mediation is one such tool. It's not the panacea. It's not everything. It's just it's a tool. And the nice thing about mediation is that it allows the emotional charge to be addressed, the underlying emotional charge that keeps the conflict alive and ensures or gives us a much better chance of getting to a lasting resolution. And mediation is especially suitable in the workplace for personality conflicts where there's a lack of trust, for poor communication where people aren't listening to one another, where a continuing relationship is necessary and your employees are not showing respect to one another, where there's strong emotionality, in particular anger, displays of anger, and misunderstandings where your employees are starting to blame one another. Those are all relational kind of issues, but workplace mediation is also suitable for the more tangible disputes that arise that may focus on leave, benefits, pay, and the like. So there are a lot of situations where mediation is suitable. In addition to that, I think the figure that's sort of accepted worldwide for the resolution of disputes through mediation is about 80%. So that's a pretty good return. In summary then, if we look at the sort of focusing on the second part of that question about should organizations be using mediation internally, what we can see is that mediation internally is going to mean less money is going to be spent on conflict, less time is wasted, there's going to be less absenteeism, less turnover, less general negativity, stress, complaints, investigation, and escalation. And by contrast, where organizations start using mediation, we see that you're spending your money wisely. There's time to collaborate. There's productivity. Your teams are engaged. Your employees have harmonious relationships. There's trust and respect. There's empathy. There's learning and growth. And finally, there's resolution and reconciliation. So the bottom line, at least in my opinion, is internal workplace mediation does make sense. So with that attended to, in other words, that first question of what is mediation and should organizations be using mediation, and my belief is the answer is a clear yes, which leads us to that second question, which is should organizations be using their HR professionals to conduct these mediations? And obviously, I think it's pretty clear to all of us, but just to sort of underscore the reality that human resources are the folks responsible for managing people. And so in that sense, are responsible for managing conflict. I don't think anyone disputes that. But as I said, what we now need to do is to look at the arguments for and the arguments against. And we're going to start with the arguments for HR professionals mediating internal workplace disputes. And the place I'd like to start is with the HR Certification Institute. It's an organization that was founded in 1976 in the United States, and it's considered to provide the gold standard in HR certification here. And there are two certification designations that are especially popular, the PHR and the SPHR. And that stands for Professional Human Resources and Senior Professional Human Resources. And those are the two as I say, the gold standards. It's interesting to see that they have employee and labor relations, and they suggest that at the PHR level, they should be spending about 20% of their time on those issues, and at the senior level, about 14% of the time. But clearly, they consider employee and labor relations to be part and parcel of human resource professionals' responsibility. And very specifically, when we drill down into what they say that human resource professionals should have techniques and tools for facilitating positive employee relations. And they specify things like surveys, dispute and conflict resolution, labor management, cooperative strategies. But you'll see I've emphasized that word facilitation because mediation really is a form of facilitation. So they clearly are of the view that HR professionals should be getting involved in helping their employees work out their differences. Then we have SHRM, the Society for Human Resource Managers, and this is the largest human resource management organization in the world. And in 2014, they came out with a competitive certification model where the HRCI model is based more on knowledge. Theirs is a competency model. They articulated 9 competencies, and one of them is relationship management. And you can see they have similar designations. Theirs is SHRM CP, and SHRM SCP, and that stands for certified professional and senior certified professional. But if we focus on the relationship management competency, well, we'll get to that in a moment, but what SHRM is really sort of saying, as I say, is that their desire is to focus on competencies and the application of the knowledge, where the HRCI standard is really more a knowledge-based one. But SHRM is really saying employees expect that not only do HR professionals have the knowledge of the concepts and the requirements, but that they can actually do something about it, and they can do things through a variety of behavioral competencies, and one of them is relationship management. And they say that in order to develop this competency, human resource professionals should maintain productive interpersonal relationships themselves. So they need to have the capacity to get along and to resolve their own interpersonal conflicts. But they add something, and they say, and they need to demonstrate an aptitude to help others to do the same. So if you're an HR professional, it's not good enough for you just to have good relationships with others. Your job is to help others to do the same. And they've broken it down. They distinguish between early, mid, senior, and executive level. And this is the summary that's on the SHRM website. And if you look at it, at the early level, they say, early level HR professional needs to provide basic information for the resolution of conflicts. At a mid level, they need to be able to recognize employee relations issue in a proactive manner and either resolve the issue or move the concern to senior leaders. If you read a little bit more, you'll see they actually use the word mediation in relation to mid-level HR professionals. At a senior level, they say they need to be able to mediate difficult employee relations and or other interactions as a neutral party. This is SHRM saying this. And finally, at the executive level, the expectation is not so much that the leaders are getting in the trenches and actually resolving things, but that they're the ones that are creating conflict resolution strategies and processes to manage through conflict, the conflict throughout the whole organization. But clearly, a strong endorsement from SHRM to say that there should be mediation taking place, and by HR professionals. Jumping across the pond to the United Kingdom, the Chartered Institute for Personnel and Development in 2013 came out with a guide, Mediation and Approach to Resolving Workplace Issues. So clearly they're of the view that HR professionals should be conducting internal workplace mediations. The Advisory, Conciliation and Arbitration Service, also in the United Kingdom in 2017, came out and started offering a certificate in internal workplace mediation. So again, clearly they're of the view that HR professionals should be conducting internal workplace mediations. David Little, a thought leader and also from the United Kingdom, he's about to come out with a new book called Managing Conflict, A Practical Guide to Resolution in the Workplace, says successful HR professionals get mediation and they value mediation as a credible and mainstream activity within their organization. Jumping back across the pond to the United States, we have a Tufts professor, Jeswald Salakus, saying leaders need to become mediators. Again, in 2017, an article appeared on the Huffington Post. That was in February 23rd. Mediation, the High Art of Conflict Resolution. And the author, Thomas Madsen, says, conflict resolution is never easy, and there is no silver bullet. However, out of all of the existing tools and methodologies for conflict management, mediation, if done right, has been proven to be very effective. If you think that there are too many internal conflicts within your company, and if you're looking for a viable solution, mediation may well be exactly what you're looking for. And then I found a couple more recently, the Business and Management were offering I think this was an article that they had on mediating workplace conflicts, and this is for leaders and managers in the workplace. June 22nd, they came out with that article. Columbia University recently hosted a webinar themselves on human resources and organizational conflict, where they explored the role of human resources working to prevent or mitigate conflicts. So clearly, there's a lot of arguments in favor of HR professionals conducting mediation internal to the workplace. What about the arguments against? When I conduct my online class mediation fundamentals for the HR professional, one of the discussion topics that I get the students to engage in is this very topic that I'm addressing today. And you can see here the discussion is framed as, what's your opinion about mediation being conducted internally? What are your reservations? And the last time I ran the class, these were the reservations that came up. First up, HR lacks the skills to mediate effectively. So it's one thing to say they should, but are they skilled? Another concern was the lack of leadership support and sponsorship. There's also concerns about not taking sides, in other words, being neutral. Well, of course, it's interesting that SHRM specifically used that term, neutral. There's also uncertainty about confidentiality, and then the risk as expressed by compliance attorney. So these are all the reservations that are leading people to say maybe not such a good idea. As I say, those were my students in the online class. I also posted an article on linked.com. This is back in April 2016. Again, asked the same question, see what I would discover. And here's the sort of the summary of what folks had to say. And if you are in HR, I just sort of say brace yourself, because this wasn't really very kind. They said, HR remains a reflexive and aggressive defender of management and corporate policies. It's part and parcel of a creeping HR overreach. Or the third bullet, there are too many issues that have significant legal implications and can lead to potentially substantial exposure. Another person suggested that it really depended on how HRs are perceived. That's sort of, you could say, is somewhat neutral. Another person pointed out, well, yes, there's a difference between internal mediators and external mediators, and suggested that sometimes when mediation's indicated, it would be better to bring someone in from the outside. And then finally, someone saying there's this fundamental rock and hard place for HR, and that it's hard for them to overcome the appearance of a conflict of interest. So these, again, are all the reasons that people were giving on LinkedIn as to why HR professionals shouldn't be conducting these mediations. This year, I attended the NCHRA, that's the Northern California Human Resource Association conference. It's called the HR West Conference 2017. And there was this really interesting presentation. What is the perception of HR? And the folks used Facebook to garner those insights. And again, if you're in HR, brace yourself. This was some of the feedback they got. They need to put the human back in human resources. I would never be honest with HR. They would find a way to punish me. HR is in bed with management, not a trustworthy or impartial employee advocate. And then this final one, my understanding of HR is that they exist to prevent employees from suing the company. They mainly do that by ensuring the company fulfills its legal obligations to its employees, like pay, benefits, and work conditions. But while they may sometimes appear to be advocates for employees, they will always represent the company's interests and will always take the company's side in any conflict. Pretty damning comments, again, on Facebook as presented at this HR West, sort of suggesting that HR is not trustworthy, that they can't discern conflicts of interest, and that they can't act in a neutral way. Well, that's their view. I'll just say my take on all of this is that skills like mediation can be taught. Perceptions that HR exists to protect management can be changed. Honestly, I'm of the view that HR is meant to be there for everyone. And again, that's really strongly endorsed, certainly by the SHRM competencies. Support from leaders can be garnered. In other words, we can engage and get them to understand the benefits of mediation. We can also clarify the extent to which confidentiality will or will not be offered. And we can do all of this in a way that still ensures that we are compliant with whatever local laws are applicable. But it still leaves that question of neutrality. In other words, what about that question of HR folks not being able to be neutral? And I'd like to share with you some of my reasoning as to why I believe these concerns about neutrality can be addressed. The first one is that authority figures endorse it. In other words, and I've already been sort of making this point, is that the leading membership organizations for human resource professionals, both in the US and in the United Kingdom, advocate the use for it. And again, SHRM specifically uses the term neutral as a behavioral competency to describe what is expected. So you'd like to think that if SHRM and CIPD are saying mediate, they've done their research, they've come to the conclusion, and they certainly are not about putting their members in harm's way. The second reason, in my view, is that we shouldn't be having double standards. In other words, no one questions HR's ability to conduct investigations with neutrality. In other words, without taking the sides of management. And we all know that when there is indeed a conflict of interest, as sometimes occurs, and HR professionals feel that they're unable to maintain an appropriate level of neutrality, they bring in someone from the outside to conduct that investigation. And I would just sort of say, what's different about mediation? I truly believe HR professionals are capable of discerning conflicts of interest and making ethical choices, and when appropriate, bringing in someone from the outside. And again, there certainly shouldn't be double standards and treating investigations in one way and mediation in another. The third reason, especially when we look at the SHRM competency guidelines, is we could say it's part of the HR professional's job to say neutral. And that what we really mean by that is that HR professionals need to be able to balance the needs of the organizations with those of the employee while navigating these potential conflict of interest situations. And in my view, HR professionals are already doing this and are already mediating with great success. So my sort of take on that really is just to say, keep on doing a great job, HR professionals. And then my fourth and final reason about why I think neutrality is not such a concern is that in a certain way it's much ado about nothing. If you look at most of the key definitions of mediation, including mine, they don't qualify the third party as neutral. Rather, the focus is on acceptability. So if we go back to Jesdwell Salakuz and his 2000 book on leadership, he points out, he says, absolute neutrality is not essential to effective mediation. What's more important than neutrality is that the two disputants accept you in the role of mediator to help resolve their dispute. And what I think a lot of mediators consider to be like the Bible for mediators, the mediation process by Christopher Moore, he's into his 4th edition. Here's his definition. Mediation is generally defined as the intervention in a negotiation or a conflict of an acceptable third party. So, as I say, neutrality not essential. I'd now like to move on to the next sort of subtopic, which is at a more practical application level of saying, where is that bright line? And the bright line is really helping us discover the distinction between practices within your organization that are safe and practices that are in your organization that are risky and that are going to expose you to litigation. To do that, I'd want to take a little bit of a sidebar and just to talk a little bit about the investigation, because especially here in the United States, it's seen as a vital tool for HR professionals, and I certainly endorse that it is indeed a vital tool for HR professionals. The investigation is really a fact-finding process in which the investigator, who should be neutral, makes recommendations based on the facts that they find after listening to whoever the witnesses are, the law and the company policy. The investigation is seen as excellent compliance protection. There are a lot of laws in the United States that basically require and mandate that when an organization gets notice of an allegation of discrimination or things like that, it has a positive duty to conduct an investigation. So when it doesn't do it, it's putting itself at risk. So it is indeed seen as an excellent compliance form of protection. The problem with it, though, is that it doesn't get to the root or the underlying issues. In other words, the investigation will often conclude that there's no exposure for the company, but you now have two employees that are really unhappy. The employee that complained and didn't feel that they were supported because the finding wasn't that there was discrimination or harassment, and then the manager who was maybe pointed at and the allegation was made about, who felt that they were an innocent victim whose reputation had been tarnished. So while the company may be breathing a sigh of relief and saying, we're not exposed, these two employees have still got their conflict, and it's going to keep coming back and nagging and causing hassles for you in HR. So that's a big problem. While it does provide protection, it doesn't get to the root cause. And in fact, it often makes things worse. But what we do know is that for the most part, the compliance attorneys encourage a more cautious approach, and so they're going to suggest, when in doubt, investigate. And it's for your compliance attorneys that I'd like those of you that are sort of contemplating mediating to take these questions back to them. First up, is mediation permissible when there's no legal duty to conduct a formal investigation? Second, is it permissible to investigate and mediate at the same time that when a duty to investigate exists? And then finally, post-investigation, is mediation permissible where there's been no breach of law or company policy found? I've got my view on these questions, but I think it's important that I'm not an attorney, I'm not giving an advice here, that you take these kind of questions back to your attorney, because what they're going to help us with is discerning that bright line. My view is that it is permissible to mediate when there's no legal duty to conduct a formal investigation. I also believe it's possible to mediate at the same time that a duty to investigate exists, although it's much more risky to do that. And also post-investigation, in my view, there's no reason for people not to investigate. And I'll say I have mediated in all three of these situations myself, which leads me to my articulation of where I see that bright line existing. In other words, when it is safe to mediate. So first up, it's safe to mediate when there's no legal duty to conduct an investigation. It's also safe to mediate after you've conducted your investigation. It's also safe to mediate prior to a formal complaint or charge being filed with an external enforcement agency. And again, I'm just trying to help you see where it's absolutely safe. Fourth, it's safe prior to the formal filing of a union grievance if you're in a union environment. And it's always more safe when you do any of these mediations with a signed agreement to mediate. Conversely, we can say that it's not safe to mediate when the dispute exists between the organization and the employee. In other words, it's less of an interpersonal dispute. It's really between the company and the employee. Where there's a duty to investigate, again, I believe you can, but again, I'd say you're putting yourself at risk there. Of course, when the employee refuses, and again, there's a whole interesting debate about whether mediation should be mandated in the workplace. If there is indeed a conflict of interest and you don't think you can maintain neutrality, again, I'd say not safe. And finally, if you have a strong opinion about the subject matter of the dispute, in other words, you may have a bias and don't think you can maintain impartiality, again, not safe to mediate. So those are the situations where I would say it's both safe and not safe. What I'm going to turn to now is just a couple of practice tips and to share a little bit about some learning opportunities. I don't want to go into too much detail, but I did want to share something that's sort of practical, or at least just reveal, as I'm going to now, my three big sort of what I see as my three big tips. And the first one, as a general proposition, it's best to nip conflict in the bud. And in many ways, when I look at my career, that's exactly what I've been trying to do. Someone fortunately suggested to me, he said, John, you need to swim upstream away from the courthouse. And what he was really saying is get to the conflict early. Whenever you get to it early, it's always going to be easier to attend to. And guess what? HR professionals, you're upstream away from the courthouse, and you have a great opportunity of nipping conflict in the bud, taking care of it in a lasting way. The other piece tip that I wanted to share with you is what I consider to be the mediator's two key skills. The first is that we are, as mediators, empathic listeners. In other words, we summarize, or we have a capacity to summarize what the participants are feeling and needing. And when we do that, we're giving them empathy. And the second sort of key skill, in my view, for mediators is negotiation. And that ultimately we're the guides, and that we guide the participants to focus on needs or interests, not on positions, to focus on the problem, not the person. So that's one little just sort of very basic sort of high level tips, but to me they are really foundational. What I'm in some ways a little bit more excited to share with you about is what I've articulated as the mediator's stance. And it came to me when I was writing my book, Peace at Work, and I realized that while a lot of the time there are opportunities in-house to sit down and to with a degree of formality to mediate, a lot of the real opportunity for HR professionals in-house is just to adopt stance of the mediator. In other words, to embody what a professional mediator would do as you go about your day-to-day business. And one of the things I know that it does, it ensures that you don't get caught between a rock and a hard place. And you can see there's an inner square that gives you an inner core strength, and then there's the larger geometric image that sort of gives you a sense of how you reach out to the participants. So in that inner square, we have the importance of keeping it real, of being authentic. That you also, as the mediator, always want to be relaxed and calm. You don't want to be agitated and nervous. That you constantly want to be open to feedback, sensitive to subtle feedback, but certainly open to the feedback that you're getting from the participants. You want to constantly respect differences. That's sort of foundational to being a mediator. And then we get into those aspects that sort of pertain more to how you're relating to others. Firstly, that we're a process guide, not decision maker. Second, that we're balanced and omnipartial. And by that, I really mean that's sort of code for neutral. That we're constantly seeking to build rapport. And so we're an empathic rapport builder with everyone constantly. That we do keep confidences. Whatever we say we do, we will do. And finally, we're an inspiring beacon of hope. Now, all of these are, this mediation stance is something that I address in the course Mediation Fundamentals for the HR Professional. As I said, we're going to be offering a couple of learning opportunities. So first up, we will be notifying all of the participants who showed up today by email tomorrow when we send the webinar link, when we send the PowerPoint, the names of the two folks that are the winners to an enrollment in the self-study program. And everyone who participates will be entitled to a 25% discount in the course. Now, the course that I'm talking about, I'm currently offering to the UC Berkeley Labor and Employee Relations Group. The form they're getting has an online component, and then they also have a 3-day boot camp where they actually practice over and over the skill of mediation. So that's one way in which it's offered. I also offer this class over 7 weeks as an online experience. And here's some of the testimonials from the participants in the last course that I offered, expressing their confidence, how it prepared them to be an effective mediator, that they enjoyed the course, and that they're able to use the knowledge and skills on a day-to-day basis. But I also offer the same class as a self-study version, where you get access to all the materials, and it's this that we're going to be offering to, well, there are going to be 2 winners of this that will get this for free, and for the rest of you, if you want, you are entitled to a 25% discount. And again, this information will be included in the follow-up email that we'll be sending out tomorrow for you. Also, you'll get information about this. If you're not interested in that course, but you'd like a little bit more to learn a little bit more on your own, you're welcome to go and download my book to get a white paper on the cost of conflict and a report that I wrote on the 3 massive mistakes HR professionals make that keep their workplace toxic and leave them dreading the next day at the office. And if you think that's of interest to you, to say, please do go off and download that. We're now, and I wanted to check my time, we're at 9:48, so we've got a little bit of time for questions. As it says there, we're going to get to all of them either today on this webinar or by a follow-up email, and Giuseppe's going to help me with the managing of the questions. So, Giuseppe, if you're...
Sure. So if you have any questions, just enter your question for the Q&A. While you were presenting, John, there was a question, but you have already answered it, and that is that at the end of this webinar, everybody will receive a copy of the video recording. Okay, so one question is from Lynn: why not push further upstream to the line managers?
I would agree. In other words, I would say yes. I would say I would agree with that entirely. In other words, I'd say yes to HR professionals being the mediators, but I think you're right that the managers are even further upstream, and a lot of the time HR professionals only get wind or get insight to that there's a conflict after already a whole lot of damage has been done. So I think equipping your managers, your supervisors with general good conflict resolution skills and the ability to be able to support their employees address their conflicts. I think it's a great idea. Another thing that I would strongly encourage is alerting them to the danger of toxic triangulation, because I think a lot of times they're well-intentioned supervisors and managers that try to help out and actually just make things a whole lot worse. Because again, mediation is a form of beneficial triangulation, and on the other side of triangulation, we have toxic triangulation. So we want to be really careful about that. And the other thing that I think we can do with our managers and supervisors is encourage them to be more proactive, to see what they can do, and then to contact us in HR and to alert us to situations earlier rather than later. But 100%, Lynn, I agree with you. Everyone really should be engaged in resolving workplace conflict, and the higher up the stream we go, the better.
Okay, another question from Sarah. Are there, let me see, are there any certification programs available for mediation?
Sarah, it's a debate that rages in the field of mediation. In other words, whether there should be a formal certification requirement. There are some legal jurisdictions that require certification for mediators to participate in their programs, but in a general way, there is no mandated requirement that people are certified. So, for example, what you do find, though, is that universities and other entities will offer certifications, but they're really certifying participation. The course that I'm offering right now to UC Berkeley, that's being done in conjunction with UC Hastings, and we're going to be offering them a 40-hour certificate, both from the HR Mediation Academy and UC Berkeley. But there are other, as I say, there are other universities and what have you that do offer certifications out there.
All right. So next question is, as an existing mediator, how do you present skills and need to potential business clients?
Well, that's the marketing question, and I think that's the reality. Is that as an existing mediator, if it's one thing to be a great mediator, it's one thing to have your great skills, but if you can't, as it were, influence someone to say yes, that this is a good idea, your business is going to dry up. So ever since I got started as a mediator, I realized that focusing on our marketing skills is really important. I don't know that there's a simple answer to that. All I know is that I've been able to maintain a successful workplace mediation practice. I think the awareness of mediation in the workplace is growing. And while I am a big proponent of HR professionals conducting mediation internally, just like with the investigation, a lot of the time they know either that because of a conflict of interest or maybe just because it's beyond their skill level that they need to bring in someone from the outside. So my encouragement actually is to start hanging out with HR professionals, talking to them, educating them about the benefits of mediation, being able to address their objections as to why they think mediation wouldn't be appropriate. And I think you'll find, I've certainly found them to be very receptive. And I'll tell you, there are a lot of, wherever you live in, wherever you may be, there are organizations with conflicts internal that are waiting for external mediators to come in and basically bring peace to that organization. So I'll just say it's a marketing challenge. Keep at it.
All right. One question is from Devika, if I pronounce the name correctly. Do you think that practical mediation training should be incorporated in HR management training? And if yes, why?
Well, firstly, practical mediation training, to me, what you're really getting at is that sort of idea that to learn an applied skill, you can't just learn the theory. For example, if you want to learn how to play the piano, you can watch a video, you can listen to someone telling you how to play the piano, but you actually have to practice playing the piano to learn how to play the piano. So in my books, if you want to learn the skill of mediation, you have to practice that skill. So in that sense, yes. Won't you just repeat the other part of the question, Giuseppe?
The second part was if the practice part should be incorporated and why.
Yes, and so to me, I'm saying it should be. And in terms of the why question, I like to think that my webinar was addressing a big part of that why question. To me, it makes it. Those are the reasons I was trying to give as to why it makes sense. And again, you've got SHRM saying it very clearly. That's the largest human resource membership organization in the world that they have identified that. The reality is that all organizations have conflict. There's no doubt about that. All organizations have conflict. What distinguishes some from the others is how they deal with it. And mediation offers a wonderful way where you can restore relationships, learn from what's going on, maintain peace for the organization, but also for you. You can have your own peace of mind.
Okay, if I can add a comment, John, I would like to mention the fact that Joe and I have discussed the possibility of offering online workplace simulations, so that after HR professionals have attended the training, if they want, they can practice whatever they learned online. But that's something that Joe and I have discussed only briefly. So let's see if there is enough interest in that. So next question is, well, a comment. Wonderful summary of issues. Thank you. Okay, thank you very much. Okay, how do you approach HR to contract with them as an external mediation resource? I think we've already addressed that. Is a market.
Right, and I will, and I'll share a little. This to me is a very valuable little tip that I'm going to share. It's really helped me, and it's been a little bit of I wouldn't say a complete game changer, but it's really taken some of what I'd call the dips out of my mediation practice. Is that employee assistance programs are starting to use mediation in themselves. So classically, employee assistance programs offer counseling. I was recruited by a local employee assistance program, and they are keeping me so busy. That's what I'll say. So if I was you, wherever you are, I'd look to employee assistance programs in my area. I'd speak to them as well as going to the HR practitioner conferences, networking events, and things like that.
Okay, now the question is, how do we know when we can handle it ourselves, or we need to call in a professional mediator?
It's a tough question to answer in a very short period of time. But I think part of that path is firstly actually taking the training, because I do think that as much as it is a beneficial thing that people are doing, I think it is vital that you make sure that you're getting the training. And that you have ways of being able to assess the severity of the conflict. In other words, the intensity of how acute the situation is. What I always encourage is doing pre-mediation caucus sessions, in other words, private meetings with each of the participants, and that normally will give you a read as to whether this is mediatable or not. So I would just say approach it with caution, make sure that you're trained, and just really be careful. Giuseppe, I wanted to quickly say, because I know we're approaching the hour and we wanted to end on time, but we did want to end with the last poll.
Oh, yes.
So what I would suggest is that we could do that, and then just to the other questions that we haven't got to, we'll send an email with short replies to that. So the last, just because I am kind of curious to see if we've had a shift from the numbers that we had up front, the 46, 26, 31.
Okay, so
let's see where we're at the end now.
All right, great. Okay. Okay, let's wait a few more seconds.
Mm-hmm.
The results are coming in.
Okay, it's exciting. I feel like
I think we can enter the poll now, and we can share the results. So now, more people think that HR professionals should be able to mediate internal workplace disputes.
I think it's so. I'm happy, Giuseppe.
There has been a shift.
There has been a shift indeed.
Okay. Well, what's the time now? Let's see.
I believe it's 10 o'clock. So let's say thank you to everyone.
All right.
It was a real honor, a real pleasure. And as I says there in that final slide, we're going to be sending you an email with a link to the replay, the PowerPoint deck, and whatever the little freebies. And if some of you want to sign up for the online classes, you'll have information about that. But thank you, everyone, for participating. And thank you, Giuseppe, again, for being the wonderful host, and Mediate.com for being the great sponsor.
Thank you very much. Thank you, everybody. And we look forward to see you again then. Bye now.
Thank you.
Bye.
Bye-bye.